Welcome to Family Court Services Orientation and Mediation. I'm Judge Mary Greenwood, and I'm here to welcome you on behalf of the Santa Clara County Superior Court and to do a brief introduction to this process. Mediation is a problem-solving process in which professionals from Family Court Services will work with both of you to develop a plan for the custody and visitation of your children that's in the best interests of your children. There are two components to it. The first is legal custody. Legal custody includes the right to make decisions about the child's residence, health, education, and welfare. And it can be either joint custody or sole custody. Joint custody means that both parents have the right to make these decisions. Sole custody means that one parent has the exclusive right to make these decisions. Physical custody is the other component of custody, and this also can be either joint or sole custody. Joint physical custody means that both parents share significant periods of physical custody of the children that assures frequent and continuing contact with both parents. It does not mean that the time will necessarily be equal or 50-50. Sole physical custody means that one parent provides primary supervision and physical control of the child or children. The other parent still has visitation rights. There are special rules that relate to cases in which there is a domestic violence protective order. Family Code Section 3044 states that it's presumed that a parent who is found to have committed domestic violence cannot be the custodial parent of children. Often the court will order visitation in ways that will keep your children safe, even if you cannot be the custodial parent. And the presumption can be overcome in certain kinds of ways. But it is very important that you understand this provision of the law. The mediation process will be conducted in a different way if there is a restraining order in place as well. The parties will be physically separated, and the mediator will go from person to person during that process. Through mediation, your goal should be to develop a plan that is practical, that provides consistency and stability for your children, and that makes a healthy relationship with both parents possible. Your approach or your mindset is very important as you enter into mediation. It's important for you to know that mediation is not about winning or losing. It's about reaching a solution in your child's best interests. You are no longer partners, but you are still parents, and you are the important adults in your children's lives. Your child will look to you to see how you solve this hard problem. They need to see that although things will not be the same, they will eventually be okay, and you are the ones who model that by reaching a plan together. You want to come to mediation with ideas, you want to be open to ideas, and you want to be flexible. You want, above all, to work towards your children's best interests. Children should not be forced to choose between you. They love you both. They have a right to a healthy relationship with both of you and each of you. You want to do the hard work now of reaching an agreement so that you avoid constantly returning to court and being in conflict with one another. And finally, most people find that they are happier if they reach an agreement for their children together about custody and timeshare. We wish you the best for you and your children as you work through the process of mediation together. And now, turn you over to the professionals at Family Court Services. Thank you very much on behalf of the court.
Part 1, Mediation Overview. Introduction to mediation. Mediation is required whenever there is a dispute about child custody or visitation. Mediation focuses on developing an agreement between parents that is in the best interests of your children. California law defines 3 purposes of mediation: to reduce conflict between the parties, to develop an agreement ensuring the child's close and continuing contact with both parents consistent with public policy, and to effect a settlement regarding visitation rights that is in the best interests of the child. Mediation is here to assist both parents to reach an agreement. Mediators will help you work out the terms of a parenting plan with the other parent. Your parenting plan may consist of how you will share time during the school year and summer, holidays and vacation schedules, transportation and exchanges, and other important details. What if we already have an agreement? If both parents agree to a parenting plan, then there is no need for mediation. To make your plan a court order, you must provide a written agreement to the court for approval. If you have an agreement but need assistance with the paperwork, let us know so we can help.